Mr. President, members of the Court, the Court has heard from Dr. Mueller the facts which impel Nicaragua to initiate this case and this request for provisional measures. And Professor Pelé has just explained how Germany's conduct in relation to the ongoing situation in Palestine entails its responsibility under international law. That responsibility arises under two broad headings. First, Germany's responsibility for its failure to take the action required by international law to prevent and punish the commission of genocide and of serious breaches of international humanitarian law. And second, Germany's responsibility for its actions or omissions that have facilitated and continue to facilitate the commission of genocide and of serious breaches of international humanitarian law. That is, the responsibility for Germany's omissions and for its own acts. It remains for Nicaragua to address the criteria according to which the Court exercises its discretionary power to indicate provisional measures under Article 41 of the statute. The criteria are well established. There must be an admissible claim concerning a legal dispute over which the Court has prima facie jurisdiction. As to jurisdiction, Nicaragua relies on the declarations accepting the compulsory jurisdiction of the Court made by Nicaragua and Germany, respectively, under Article 36 of the Court's statute. As is explained in Nicaragua's application, there are no reservations in either declaration relevant to the present case. Nicaragua's reservation relates to matters before 1901 and Germany's to the deployment of its armed forces abroad in the use of German territory for military purposes. In addition, Article 9 of the Genocide Convention, to which both Nicaragua and Germany are parties, provides jurisdiction over certain aspects of Nicaragua's case. It is evident that these grounds, prima facie, afford a basis on which the jurisdiction of the Court might be founded. The legal dispute was described in Nicaragua's letter of 2 February 2024, in which it specified the breaches of international law for which it considers that Germany is responsible. The breaches relate to obligations under the Genocide Convention, the 1949 Geneva Conventions, and additional protocols, and customary international law. Germany announced its rejection of Nicaragua's claims on 7 February 2024. Nothing more was heard from Germany on the subject on a bilateral level, but Germany continued to reiterate publicly its support for Israel, evidencing the difference of positions with Nicaragua and the subsistence of the dispute. On 1 March 2024, Nicaragua filed this application with the Court as the only avenue holding out any hope of swiftly upholding the application of international law. The timescale and bilateral level of intercourse was not lengthy and extensive, and that is as it should be in a case where the allegations concern an ongoing genocide and grave violations of international humanitarian law. It would be a blind retreat into formalism to require round upon round of diplomatic exchanges to reiterate the flat rejection of Nicaragua's claims that Germany had made on 7 February and its reiterated public support of Israel's actions in Palestine. This rejection was again evidenced in Germany's note verbal of 11 March 2024. Mr. President, Nicaragua's claim is plainly admissible. This question has been discussed in Professor Pelé's presentation, but it is relevant to emphasize it in the context of the criteria for ordering provisional measures, which is here under discussion. As a contracting party, Nicaragua has a legal interest in the protection of the rights secured by the Genocide Convention. The point was reaffirmed earlier this year by the Court in the context of South Africa's request for provisional measures. It is plain that the same is true in respect of the 1949 Geneva Conventions and additional protocols and of customary rules of international humanitarian law, which they embody. The Court itself has said, I quote, that all states parties to the Geneva Convention relative to the protection of civilian persons in time of war, 12 August 49 are under an obligation, while respecting the United Nations Charter and international law, to ensure compliance by Israel with international humanitarian law as embodied in that convention. I'm citing your advisory opinion on the Wall case. These are obligations erga omnes or erga omnes partes, and each other state or state party has an interest in compliance with them in any given case. The Court's jurisprudence refers to 4 other considerations to be taken into account in answering a request for provisional measures. 1, the plausibility of the rights claim. 2, the link between the provisional measures sought and the rights underlying the main merit claim. 3, the risk of irreparable harm. And 4, the urgency of the need for provisional measures. They all go to the basic question whether provisional measures are necessary in order to preserve rights which may subsequently be adjudged to belong to either party in the case. The plausibility of the rights claim and the link with the rights sought required are evident in the present case. As in the South Africa versus Israel case, there is here, and I quote, a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party, end of quote. And the same is true of rights under the Geneva Conventions and international humanitarian law. The rights of members of groups protected under the conventions and international humanitarian law, here the Palestinians, are self-evident. They include the right to be spared from genocidal attacks and treatment that fails to reach even the basic standards of international humanitarian law. Nicaragua seeks to secure compliance with the obligations that underpin those rights. But in this action against Germany, it is not for compliance with the obligation to refrain from such attacks. Rather, as already stressed by Professor Pelé, the obligations of Germany that are in question are its obligations to take actions to prevent or punish breaches of the Genocide Convention and of international humanitarian law, and to refrain from complicity in or facilitation of such breaches. These obligations have indisputably arisen in this case. The existence of this obligation for states parties to the Genocide Convention and its engagement in respect to the attacks in Gaza has already been determined at least since the order of the Court of 26 January 2024. It can scarcely be denied that the same is true in relation to the obligations to prevent and punish breaches of the Geneva Conventions and of international humanitarian law, as Professor Pelé has explained. The Palestinians are being denied the rights to protection and are dying and being injured and having their homeland reduced to rubble because of it. Similarly, Nicaragua is also requesting provisional measures on the basis that Germany is not only failing its duties to prevent and punish these breaches, but that it is complicit in them by aiding and assisting the commission of the breaches. The facts in Gaza and the other parts of the Palestinian-occupied territory are notorious. They have been filmed and reported on and broadcast for the past 6 months, in spite of the difficulties and the more than 100 journalists killed. In its last order of 28 March 2024, the Court referred to, and I quote, the catastrophic situation in the Gaza Strip and the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, end of quote. Germany cannot but be aware of these statements by the Court. In fact, Germany has announced its intention to intervene in the case lodged by South Africa in favor of Israel. So it is obviously aware of the orders of the Court in this case. Mr. President, Germany cannot but be aware that the munitions, the military equipment, and the war weapons it is supplying is being used by Israel in these attacks. It does not matter whether an artillery shell is delivered straight from Germany to an Israeli tank shelling a hospital or university, or whether that artillery shell goes to replenish Israel's stockpile for use at some later date. It doesn't matter whether the planes used in combat and to drop 1-ton bombs on the population were made entirely in Germany or just their spare parts and maintenance were supplied. The fact is that the assurance of supplies and replacement for armaments is crucial to Israel's pursuit of the attacks on Gaza. That much is evident from the emergency arrangements made by states such as Germany and the United States, among others, to continue with military supplies to Israel, even during the actual conflict in the face of daily breaches of international humanitarian law. These are the rights that Nicaragua invokes, and their plausibility is beyond question. But there's another aspect. Nicaragua is also seeking here to protect its own distinct rights under international law, which raises a principle of the greatest importance. Those distinct rights are the rights entailed by accession to multilateral conventions in which all parties bear individual responsibility for securing the aims of the convention. Those responsibilities necessarily require each state party to conduct itself in a manner that does not undermine the aims of the convention. Certainly, there are many states and organizations calling for compliance with international humanitarian law in observance of what the court has called elementary considerations of humanity in Gaza. But there are also states pouring gasoline on the fire. There are states that continue to supply or to permit companies within their jurisdiction to supply munitions of war to Israel, knowing that such weapons are being used against Palestinians in violation of international humanitarian law and elementary considerations of humanity, and are thereby actively undermining these rules and principles. Sadly and shamefully, there are also important business interests that are profiting from this ongoing Nakba. The important point is that such undermining is breaking faith with the other states that are committed to securing the basic rights and protections embodied in international humanitarian law. In more strictly legal terms, such conduct breaks the duty of cooperation in the promotion of the aims of international humanitarian law. That duty to cooperate is a general principle of international law with its own chapter in the Declaration on Principles of International Law of 1970. Specifically, it is at the heart of the undertakings in Article 1 of the Genocide Convention and in Common Article 1 of the 1949 Geneva Conventions and the 1977 additional protocols to the Geneva Conventions and the Apartheid Convention and the basic principles of international humanitarian law. It applies to all states, erga omnes or erga omnes partes. The point is that while cooperation may require much in the way of good faith efforts to pursue internationally agreed policies, it must require that insofar as a state is bound by a duty of cooperation with other states, the state must, at a minimum, refrain from actions that undermine the efforts to secure the common goals. The principle might be inferred from the broader principle of good faith. And in relation to cooperation concerning substantive duties set out in treaties, is underpinned by the rules on treaty interpretation. This focus on cooperation recognizes that while Germany happens to be one of the handful of states whose support for Israel is particularly important and a particularly direct contributor to the continuation of Israel's attacks, as a matter of law, it is obliged to cooperate with other states in using its best efforts to bring these breaches to an end. And as a matter of practicality, it will have to do so if its efforts are to be effective. Nicaragua does not at this stage ask the court to make extensive orders regarding the entire range of Germany's legal duties to take positive actions in order to ensure compliance with the Genocide Convention and international humanitarian law. Nicaragua asks only that the court order that Germany refrain from undermining that aim and making the situation in Gaza worse by providing or allowing the provision of munitions of war and other direct support for Israel at this juncture, and by depriving UNRWA, the organization that is uniquely equipped to deliver humanitarian aid in Gaza, of funding and of the ability to continue working in accordance with its mandate. Mr. President, this is the explanation of the provisional measures requested. The first request and order that Germany suspend its aid to Israel, in particular its military assistance, including military equipment, insofar as this aid is used or may be used in the violation of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. This requires a halt to the execution of any agreements for the supply of material or services that could be used or are being used by Israel for its attacks. In view of the recent news on the possible more massive supply of weapons to Israel, it is necessary to add this note on this point. It is public knowledge that Germany collaborates with the United States in several military programs related to the fabrication of equipment and spare and replacement parts, technical and logistical support, among other aspects. The United States is in the process of approving a plan to sell $18 billion worth of F-15 fighter jets to Israel, a new order for F-35 jets, and an additional $14 billion in military aid, including weapons and technology for our missile defense. If this new deal by the United States involves Germany, Nicaragua wishes to make clear that this collaboration with the United States or any other associate must cease in the current context and should also be considered as part of any measures the Court might decide to adopt. Mr. President, the second measure requested requires Germany to use whatever legal or contractual powers and whatever influence it has over Israel to ensure that weapons already delivered by Germany and German entities to Israel are not used to commit or facilitate serious violations of the Genocide Convention or of international humanitarian law. The third request seeks an order that, as part of its duties to prevent violations of the Genocide Convention and international humanitarian law, Germany resume its funding of UNRWA for its activities in Gaza. The crippling of UNRWA appears to be the biggest impediment to a distribution of humanitarian aid to the Palestinians who need it most, part of what the European Union and the United Nations have referred to as the weaponizing of hunger by Israel. The request thus focuses precisely on a step that Germany can take that will have great practical effect in alleviating the suffering and destruction. The submissions do not formally request the Court to recall to the parties the obligation of compliance with humanitarian law, as well as the obligation of cooperation to bring to an end all serious breaches of peremptory norms of international law. The reference in the submissions is simply a reminder of existing obligations that do not need to be specially ordered by the Court. The link between these measures and the rising issue at the merit stage is obvious. The measures requested are conservatory. They are needed in order to ensure that Germany stops aiding and abetting the complete devastation of Palestine, and that Gaza in particular is not completely devastated before the Court hears the merits of this case. For that same reason, the urgency and necessity for the measures is, Nicaragua submits, as obvious as it could possibly be. The killing and the destruction are continuing even as we sit in the Peace Palace of the Great Hall of Justice, at the heart of the only really global institution mandated to uphold the rule of law. Mr. President, members of the Court, in considering the request for provisional measures, I will call attention to the importance that the decision of the Court be addressed to ordering concrete measures that admit of no rationalizations in their compliance. An order by the Court that simply recalls clear pre-existing obligations that should be complied with without any specific order would not be effective. In the course of these pleadings, we have referred on several occasions to the advisory opinion on the construction of a wall. In this opinion, the Court considered the legal consequences of the internationally wrongful acts of Israel as regards other states. The situation then involved actions that in comparison to what is now under consideration would seem almost trivial. Yet the obligations then also under consideration involve similar peremptory norms of international law that in the present circumstances apply even more forcefully and urgently. Mr. President, briefly, in that case, the Court reaffirmed the obligation of all states not to recognize the illegal situation created by acts contrary to peremptory norms. Then the actions under consideration were the construction of a wall. In the present case, the destruction of a people. The advisory opinion reaffirmed the obligation not to render aid or assistance in maintaining that illegal situation. It specifically recalled the obligation, I quote, to ensure compliance by Israel with international law as embodied in the Geneva Convention, end of quote. But in dealing with the construction of a wall, the court did not limit itself to refer directly by name to one state, Israel. It also recalled the obligation of all states to ensure that Israel complied with international humanitarian law. An advisory opinion certainly is not a binding decision within the scope of Article 59 of the statute, but it represents a statement by the highest judicial organ of the United Nations on the law in force. States that do not act in accordance with international law as interpreted by the court are not violating a judgment of the court. They are simply violating international law. Mr. President, if the obligation of all states with respect to the actions of Israel in Palestine, as stated in the Wall Advisory Opinion, had been complied with, we would not be here before you today. This is why we consider that the measures ordered by the court should be clear, specific, and of unavoidable compliance. Germany, as all other states of the international community, has been aware, at the very least since the year 2004, when the advisory opinion on the construction of a wall was given, that peremptory norms of international law imposed the obligation not to render aid and assistance to Israel in its violations of international humanitarian law as embodied in the Geneva Conventions. As we have pointed out in our application in the course of this pleading, Germany, as all states of the international community, has been aware since at least the 9th or 10th of October that serious violations of international law were being committed by Israel in Palestine, and at least as from the date of the order of the court of 26 January of the possibility that these violations constituted a crime of genocide. And Germany, as of today, ignoring its glaringly obvious obligations, continues providing assistance to Israel. Mr. President, this has got to stop. That is why we have come before you and why Nicaragua makes the following submissions. I will proceed, Mr. President, to read Nicaraguan submissions. Nicaragua respectfully requests the court, as a matter of extreme urgency, pending the court's determination of this case and the merits, and after recalling to the parties the obligation of compliance with humanitarian law, as well as of the obligation of cooperation to bring to an end all serious breaches of peremptory norms of international law, to indicate the following provisional measures with respect to Germany and its participation in the ongoing plausible genocide and serious breaches of international humanitarian law and other peremptory norms of general international law occurring in the Gaza Strip, as well as in other parts of Palestine. Namely, to order that, 1, Germany must immediately suspend its aid to Israel, in particular its military assistance, export and authorization of export of military equipment and war weapons, insofar as this aid is used or could be used to commit or to facilitate serious violations of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. 2, Germany must immediately ensure that military equipment, war weapons, and other equipment used for military purposes already delivered by Germany and German entities to Israel are not used to commit or to facilitate serious violations of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. 3, Germany must resume its support and financing of UNRWA in respect of its operations in Gaza. This is the end of Nicaragua's ambitions. Mr. President, members of the court, this concludes Nicaragua's pleading. Thank you for your kind attention. I would also like to thank the registry and its staff and the interpreters for their invaluable assistance. My thanks also to the Nicaraguan team. Thank you.
I thank the agent of Nicaragua, whose statement